Welcome to our next PowerPoint presentation. In this one, we're going to discuss the legal construction of the employment environment. To me, this phrase doesn't have a lot of meaning, so I apologize for it. The way I like to look at this chapter is that we're moving from theory to practice. And I think that you'll see when we get into this chapter that it's really full of helpful how-tos in the employment world. We go from a lot of book knowledge that you need to know to be successful with employment law, but that doesn't necessarily tell you the nuts and bolts of what's the next thing up, that type of thing. And this chapter goes quite a bit farther down that road. So I think it's a place to kind of move on now that we've gotten the theory, at least the initial theory, out of the way. This chapter is about the life cycle of the employment relationship. Before we dive too deep into this, I want to pause and kind of remind you of a tension that exists whenever you're writing a book or lecturing or teaching on employment law. There's kind of two models to think about when you're organizing it. One is to organize it by statute. So you have a chapter on Title VII, you have a chapter on the National Labor Relations Act, you have a chapter on the Fair Labor Standards Act, you have a chapter on tort law, and that's one way of doing it. The challenge with that is, though, that when an HR manager or paralegal or attorney is confronting a particular issue, let's say Bob has applied for a job. Well, Bob might fit into lots of different categories. He might have a disability, he might be a member of a certain racial group, he might be obviously he's of a certain gender, he might be of a certain alternative lifestyle situation. So there's all kinds of things that relate to that one situation. And so when we're talking about one discrete fact pattern, if we have to go and borrow from about 12 different chapters, that's hard. That's hard for the person on the ground who's trying to make sense of this. So there's another way of organizing the data, and that is to organize it through the life cycle of the employee. And that's really what this chapter is about. We're going to think about the applicant all the way through his or her employment cycle. You can see here recruitment, pre-employment testing, the hire decision, performance appraisals, disciplinary process that might happen, and even termination. So you can see from beginning to end. And we're going to try to hit most of the roadblocks that can come up along that course of time. So this is kind of the life cycle of the employment relationship. It's the second way of looking at organizing a course like this, but it also has its problems because really Title VII is going to come up during each one of these categories. The Americans with Disabilities Act is going to come up with each one of these categories. The Age Discrimination Employment Act will come up with each one of these categories. So I could talk about Title VII at great length here, and then do I turn around and talk about it and say the same things here, and do I say the same things here? Well, that would be really boring. It would make this course incredibly long and not really that helpful. So there kind of needs to be a little bit of both approaches, and it results kind of in an awkwardness associated with it. So I'll talk about Title VII, and the textbook will talk about Title VII in one chapter, but we'll kind of brush up against it, so to speak, as we go through the life cycle. So don't see this as a deep dive into any one statute. You'll need to look at the chapter that we really focus hard on that. But when we're in the chapter that focuses really, really hard on Title VII, you're not necessarily going to get an examination of the entire life cycle. So you kind of need both lenses to work through, but they're different paradigms. They're both important paradigms, but if you exclusively stay in one mode or exclusively stay in the other mode, I think you're going to miss some of the things that you need to know about if you're going to be successful with employment law. So let's get started. Less theory and more practice, right? That's what the nature of this chapter is. So let's start doing some practice. We're going to start with recruitment. And here we have a list of things that come up in the recruitment context. So let's start focusing on this. And of course, you see here the list of the statutes that we care about. Again, we're not focusing on individual statutes here. We have separate chapters for that. We're going to focus on, assuming we know all that statutory stuff, what does it mean that we need to do if we're an HR professional? We need to design ads or other means of communication that will draw a diverse applicant pool. That's one of the expectations that employment law has. The employer has to figure out a way to invite lots of different folks to apply for the position. Now, obviously, communities vary in their ethnic and racial and religious composition, so there's never going to be an applicant pool that is the same from one place to another, nor is the expectation that an applicant pool is going to completely match the population from which the applicant pool was drawn. For example, there are certain career paths that more women are attracted to than men, or men are more attracted to it than women. And so really what we're thinking about are qualified applicants. So let's say that the particular position that we're seeking to hire is electrical engineer. Let's assume that the population in this community is about 50-50, 50% women, 50% men. But the percentage of electrical engineers that are male is probably significantly higher than 50%. Obviously, there are women who are electrical engineers, but they don't make up 50% of that pool. So what we would care about if we were that employer is what percentage of women in this community are electrical engineers. That's what we want to see in our diverse pool that we actually draw in. So this is an important thing to look at. And so as an HR manager, you'll want to be thinking about how can I make sure that this is seen by that diverse population. And so it's good to have your eyes and ears open for creative ways of getting that word out. These could be various professional groups, various newspapers, email lists, things like that that you want to think about, and you want to be sure that you're, again, attracting that diverse population. So here are some common tools that HR professionals use. One, of course, are some type of want ads or job postings. You'll want to be sure that when you list this, that your message is general. So you don't want to say salesman, for example. You'd want to say something like salesperson, or sales professional might even be a better term. You don't want to say something like recent college graduate or something along those lines, because while certainly people can graduate from college in their 60s and 70s, most college graduates will be in their 20s. And so that would suggest that you are focusing on younger candidates versus older candidates. So you ought to be careful, look at the ads, make sure that you are aware of what's going out, because your line managers may not be sensitive to these issues. They might not be clued into that wavelength. You want to think carefully, is there a way to interpret this ad that could create some exposure for the company? Another thing to consider are employment agencies. These can be useful tools. You want to, of course, make sure that the agencies aren't going to discriminate either intentionally or inadvertently. Most agencies are going to be very careful. If you're using a reputable agency, then that's probably not going to be a major problem. So let's talk about word of mouth type of advertising. You know, it's very popular for companies in many different industries to use a more informal system. You'll hear talk in the world that 90% of jobs are filled through this kind of informal system, word of mouth. Talk, hey, you know, the boss will come in and say, hey, tell your friends, tell your good friends who know how to do the work well that we're hiring. And that can be a way that good candidates are selected. And if this method draws in the right type of candidates, then the employer may choose to forego the expense and hassle of these other approaches. Is this approach unlawful? Absolutely not. But it's not likely to be as effective as other approaches in terms of getting diversity. Let's imagine your workforce. Let's say, again, this is an engineering operation. Let's say that 75% of electrical engineers are men and 25% are women. But it happens in your particular facility that 90% of your electrical engineers are men. If you rely upon word of mouth advertising, you're probably not going to move the bar too much. You're not going to increase the number of women that you have in your workforce because probably most men are going to have their buddies who are also men be the ones to apply. Word of mouth advertising brings in similar hires typically, and it does not necessarily increase diversity. That has some truth with respect to male and female issues, but it's probably even more commonly an issue when you're talking about different ethnic or racial groups. The term nepotism is related to this, and this refers to favoritism toward relatives. This is not unlawful. You can prefer, especially if you're a small business, prefer to hire your own employees. Sometimes that can be an effective way of managing salary costs. You know, if you're the small business owner and you hire your own child who's taking the summer off to work in your business, you don't have to pay him anything, right? Because after all, he's your kid. But and so that can be a way of saving some money. But as the business grows and you've become a more robust business, obviously hiring relatives isn't going to help your diversity because that relative is going to most likely be of the same background that you have. So let's talk about recruitment methods. Of course, we talked about advertising, word of mouth. Let's also talk about promoting from within. This is an interesting topic. It has non-law implications that I want to talk about for just a moment. When I was at JCPenney, I went to work there in 1993 and stayed until 2010. And over those years, there was a change in the culture with respect to promotion from within. When I arrived, it was very strongly a promote from within organization. I mean, that wasn't true as much in the legal department and maybe the accounting department, but in terms of the management that were involved in the retail side of the business, that was very much true. The CEO had started as a management trainee upon his graduation from college, and the CEO before that, and the CEO before that, and the CEO before that. I mean, that was pretty much the path until you got all the way back to James Cash Penney, the founder of the company. That changed, though, in the late 1990s, and somebody from outside the company was brought in part because JCPenney was experiencing some difficult times. And so he was brought in. He was a very successful retailer from other experience, and he brought in some new perspectives. And as a result, the company became more open to the idea of hiring from outside. And now I would say, while certainly promotions from within happen, my guess is, or certainly when I left, this was true, and I think it continues to be true, promotion from outside is also quite common. So, pros and cons to this. Let's look at it from a legal standpoint. If you're promoting from within and you don't have a diverse workforce, you're not going to get a more diverse workforce from promotion from within. So if your goal is to make your workforce more diverse, it's not really going to be that successful. But it's not unlawful to do so. If a company wants to promote from within and doesn't consider outside candidates, as long as it doesn't as long as it doesn't say, well, we'll hire outside male candidates, we're not going to hire outside female candidates, then it's very likely to be a lawful position. When you promote from within, you reward people who have been within your organization. People are more likely to stay because they see that they have a real chance to climb the ladder. If you promote a lot externally, then people who are already there and see people come in sometimes become demoralized. Wait a second, I've been here for a while, I've paid my dues, and now this person is my boss, and he or she doesn't have the experience within the organization. So that's a downside from promoting without. Another problem or potential problem from promoting from without is that the person who comes into the organization doesn't know the organization. There's a learning curve. Even if your decision to promote the person from outside is really, really awesome, this person is tremendous, there's going to be a learning curve. There's going to be things that he or she doesn't know on day one. How could they? And then there's also going to be other transitions. For example, he or she oftentimes has to move. There's a period of time of disconnection, of them giving notice of the former place of employment and transitioning to the new place. So there's some delay in that process that you might not have with an internal candidate. A third thing is that when you promote from without, you are creating a culture of change. And that can be a good thing, but it can also be change for the sake of change. Think about it for a second. If you bring someone in from outside the organization, he comes in, he's going to think to himself, or she's going to think to herself, well, they didn't want to promote one of the guys already there, one of the women already there. So either those guys are idiots or they want fresh blood. They want a new perspective. I want to give them what they want. And so I'm going to bring my previous experience, the ways of doing business that I've been comfortable with, I'm going to import them into this new opportunity, in part because it's what I'm comfortable with. It's what I know. It's what I've been used to. And in part because I think that's kind of what this company wants from me. Otherwise, they would have promoted from within. So it tends to create change. Now, again, that change can be a good thing, but it can also be a source of upheaval, confusion, uncertainty. All of those things can also be part of that culture of change. So those are some aspects of promoting from externally. Promoting from within encourages people to stick around. They think to themselves, well, if I stick around, my day will come. I will get a promotion because there's only so many people in this organization. Some are going to leave on their own. And if I stick around long enough, I'll be a person who moves ahead. So it rewards kind of loyalty, so to speak. But it also leads to a certain stagnation. For example, it could be that the people who leave are leaving because they have better opportunities. And so the people who end up sticking around aren't the sharpest pencils in the pencil box. They're not the most hardworking. They're not the ones who have the best ideas. And so you might find that if the best are leaving, you're left with kind of mediocrity, and that's not obviously what you want in an organization. It also means that there's not a lot of cross-pollination. I mean, everyone goes to the same training classes. They all have the same ideas. Their supervisors are all kind of the same personality. There's not much diversity. Even if the population itself is diverse, you have lots of different racial groups and cultural groups and religious groups and genders. You have all those different groups, but they've all been trained to do things the same way. And so they're going to kind of do things the same way. There isn't that sharing of different ideas. And so if the way that you're doing things currently is good, and having all those common experiences can be a really awesome and positive thing. But if you need to update those procedures, you don't really have anybody who's ready for that necessarily. So it's a difficult call how much to promote from within and how much to promote from without. But it's definitely something that the HR department ought to be aware of and think through carefully to come up with that right balance. And of course, talking to line management is going to be really, really important. Another thing to think about is venue recruiting. This oftentimes happens on the college campus, but it doesn't just happen on the college campus. There may be job fairs or other types of events that you can recruit people, and so that can be an important thing. Where are you going to recruit? And this can be an opportunity to diversify your pool. For example, let's say your population is heavily, again, we'll say the electrical engineers, heavily weighted toward men. Well, you might want to look to recruit at universities like Texas Women's University and to recruit electrical engineers there if, I don't know if Texas Women's University has that type of program. But that would be an example of something you could do to try to balance your numbers. Walk-in applicants, certain businesses are going to have people that just come in and say, hey, I want to apply for your job. Again, I'll use the example of JCPenney. Most of the applicants for a sales position at JCPenney just show up one day and apply for the job right there. The way JCPenney handled it, which is how I guess most businesses of that sort handle it, is that they have a kiosk. And there's a receptionist who shows the applicant where he or she can complete the information on the kiosk, and then the store contacts this particular candidate if there's an opening and this candidate seems like a candidate whose candidacy ought to be advanced. Let's talk about some challenges, some things that um, some things that ought to be on your radar as you consider how to prepare your process so that you get the right candidates and you also stay clear of any potential problems. Again, you want to make sure that your ads, the wording is very careful, very neutral. You don't want to say draftsman, sales girl, repairman, paperboy, maid. You don't want to say recent college graduate. All of those terms are going to be not good. So you'll have to think through it carefully. And again, don't rely upon your line manager to be aware of the sensitivity of these terms. They aren't the professionals that have the expertise in HR, and so you need to be the one who's kind of policing that. Let's look at a couple of scenarios. A job advertisement that requests recent college grads is not a neutral solicitation, one ad, and could suggest a violation of the Age Discrimination and Employment Act. Saying college grads is probably fine, but again, that's even potentially problematic because is it really essential that the person be a college grad? Think backward to Dothard versus Rawlinson that we talked about before. Is this possibly a facially neutral requirement that in fact has a disparate impact upon certain groups? So something to think about. Let's look at another scenario. Chez Robert, a 5-star restaurant, advertises for a job in the local newspaper as waiters needed, experience required, must look good in tuxedo. Okay, so Mary has worked at a 5-star restaurant. She believes she looks good in a tuxedo, but when she applies, she's rejected. And she thinks she's rejected because she's a woman, that Chez Robert only wants men to be waiters. Now, the term waiter probably isn't sexist because the term waiter, I think most people would understand, would also include waitresses. If Chez Robert had just wanted women and it said waitresses needed, then that probably is sexist because the term waitress excludes men, whereas the term waiter, I would say, does not necessarily exclude women. So this would be a fine ad, but women who can wear a tuxedo appropriately can't be rejected for the job if she is not actually given that job. Now let's change it up. Let's say the ad was waiters needed, experience required, must look good in a short skirt. Well, I would say that that probably does kind of cross the line, and it is clearly something that only a woman would be comfortable doing, wearing a short skirt. A tuxedo, there are tuxedos that are cut for women, and so you could argue that perhaps a female version of the tuxedo ought to be offered, maybe a black skirt and top or something along those lines. So probably tuxedo I would leave off, but maybe something like must look good in formal wear, for example. That might have been the better way to approach that. Employment agencies may not discriminate based upon employer's clients. So you can't, an employer can't say, well, we don't want to discriminate, but our clients really want to see a man be the waiter. That's not a lawful reason. And of course, the reality is that all employers ought to be following these same rules. So if you can't just have a man, that also means your competition just can't have a man in that role. And so the client's preferences are going to be frustrated wherever he or she goes. Think about it. If we had permitted the client or customer's preferences to control, how much progress would we have made in the 60s and 70s when the customer might have really been opposed, for example, to buying certain items from an African American in certain parts of the country. If the employer could just say, oh, we'd love to hire you, we know you're qualified, you'd be great, but our customers aren't comfortable doing that particular task with an African American or whatever, well, we never would have made progress in these areas. Similarly, this could also be the case with women and other groups too. So as a result, customer preferences usually can't be a factor. One area of exception would be in the area of BFOQs. A BFOQ is a bona fide occupational qualification. So for example, if I happen to be a person of the Jewish faith who keeps kosher, I want to make sure that whatever it is that I eat has been certified as kosher. And according to my religion, the only person who can certify things as kosher is a Jewish rabbi. And so under those circumstances, the client preference of having a Jewish rabbi certify the kosherness of the food is considered not discriminatory because it has that religious component. If I am a woman who's seeking a mammogram, for example, I would prefer most likely to have a woman perform the mammogram procedures because obviously a woman is not clothed from the waist up, and it's necessary for the mammographer to touch the breast to position it on the screen or the X-ray screen. And so as a result, when issues of personal modesty are in play or religious requirements, the BFOQ, bona fide occupational qualification, is going to create an exception. But if it's because the client or customer is a bigot, that's not going to fly. So let's talk very briefly about recruiting foreign nationals. The first thing to say about this is that if your client or if your business or company wants to hire foreign nationals, then you will likely need to consult with an immigration attorney. Labor and employment attorneys usually don't do a lot of immigration work. Although they work closely with immigration attorneys, it's a pretty specialized, rarefied area to complete the visa applications and things along those lines. And so you, instead of the attorney, might be the person who has the contact with with the immigration attorney. Foreign nationals who do not have permanent resident status in the United States would need a visa to permit them to work in the United States. And we have lots of different categories of visas that can get people to have those types of eligibility. Now for this course, you don't need to know any of these visas. I'm just not going to dive into that subject matter. If you are currently working in an industry where visas are pretty routinely used, this would provide you a good summary of how they work. But for this class, I'm not going to ask you to know the difference between H-1B and all the other visas. So we're just going to slide through this slide. We're going to ignore this one. We're going to ignore this one and this one. I'm not going to focus on this, but this talks about the possibility of human trafficking, of people, or labor trafficking is what they're calling it here, of people being mistreated as they are moved across borders. Obviously, that's a violation of human rights and a violation of international and U.S. law, and something that we obviously don't want to get involved in your role as HR professional or a paralegal. Let's talk about the application process. The application process is really an exchange of information between the candidate and the employer. Both are sharing information with the other, and both are receiving information from the other. And so there's definitely opportunities for a request to be made that's inappropriate, or for inappropriate information to be shared. And so you have to kind of manage that relationship, know where the landmines are so that you can avoid those. It's easy to mess up in this area, and I will tell you right now that to this day, before I do interviews with people, I always look over the rules some more because they aren't always intuitive, and so it requires a lot of work to anticipate the issues that can come up and to make sure that you're addressing them appropriately. As the HR manager or the paralegal in a working environment, you may be asked to train workers that might be involved in the interview process. What questions they can ask, how they can ask it, when they can ask it. This gets to be a pretty technical area, and you really can't afford to mess up in this area. So you have to be sure that everyone's bringing their A game to this process. One thing to consider as you're reviewing applications that you've received from whatever mechanism is that, I know this is shocking, but you know what? People lie. People lie all the time on their resumes. They make small lies, they make medium-sized lies, and they even make whoppers. So it is incumbent upon the HR department to do some confirming of the information before the hiring decision is made. I mean, you don't necessarily do it at this stage, but you'll want to make sure that this person has represented his or her dates of employment or job responsibilities appropriately. Confirming the information, though, can be really challenging because a lot of times places where a person has previously worked aren't going to be willing to give up a lot of information. You'll probably be able to get dates of employment. You may even be able to get titles and things along those lines, but it can be hard to get additional information. And so you have to be kind of prepared to invest. You may say, well, why should I be focused on this? What is the reason or the motivation that I ought to have to do the reference check? Well, one thing is it's really expensive to have an employee who isn't working out. There's going to be a drop of productivity in that department. There's going to oftentimes be morale problems because coworkers are having to pick up the slack. And then you have to restart that whole interview process. And so there can be all kinds of lost business opportunities and just a lot of inefficiencies in hiring the wrong person. So a little bit of time up front can save a lot of time and mental anguish later on. It's kind of like, an ounce of prevention is worth a pound of cure. So that's the practical business reason that you want to be careful about this. But there's also some really important legal reasons you want to be careful about this. One is that if you have a case of resume fraud and you hire this person and they have misled you in some respect, and you never confirm the information, you may have a negligent hiring situation. Imagine for a second that let's say you have a dental business and you hire somebody to be a dentist, and yet this person isn't appropriately licensed, or this person has lost his or her license. And then this person proceeds to perform dental procedures and they don't have the right credentials, something bad happens. Who's going to get sued? I mean, yes, the dentist will get sued, or the fake dentist, but also your business. And it's going to be very difficult to defend the fact that you didn't, look to see, is this person a licensed dentist in this particular state? So you want to make sure, especially when we're talking about customer-facing people or professionals or things relating to the medical industry or public safety or things along those lines. So think about it. Can this person harm other people? I'll give you an example. When I was at JCPenney, and this didn't happen in Texas, but in a different state, there was an individual who was applied for a position, and JCPenney conducted a background check on this position. This person was applying for a job to work in the children's department of this particular JCPenney store. And it ended up that he had a sex crime. And in fact, was a sex crime involving children. And so he was denied employment. He filed a claim with the state agency saying that he had been the victim of discrimination. And the state agency took his side. And it's crazy. It's a crazy story, but this is the logic that the state agency said. Well, this person had sexually abused his own granddaughter. I can't remember her age, but she was a young child. And there was no indication that he would have abused anyone outside of his family. So there was no reason to be concerned about him working in the children's department at JCPenney. Of course, it's kind of a ridiculous argument. And we said, no, we don't care about who he abused. We care about the fact that he abused one person, and that makes him forever ineligible to work in the children's department. Well, the department came back and said, well, children might be around the department, but their mother or their father is going to be with them. And so really there's no risk to the children in the department. But then, of course, the counter argument was, well, part of the children's department was a dressing room, and sometimes mom or dad might leave the child in the dressing room and to go get new clothes, because maybe the clothes that they had initially gotten weren't the right style or weren't the right fit. And so a child could be alone in the fitting room, with maybe not being fully dressed, and certainly in a place that had some level of privacy. And so we said, no, that's not going to work. So then the department came back and said, well, you have other departments in your store. Couldn't you move this person to, the women's department or to the furniture department or something like that? But our response was, well, guess what? Children kind of go throughout the store. They might go to the women's department with their mother. And maybe the mother might say, oh, I'm going to try on some clothes, little Johnny or little Sally. You wait out here for me. And maybe the child was a 15-year-old or a 13-year-old, and so maybe the child felt was too old to go back to the women's dressing room, or maybe it was a daughter and the dad didn't feel comfortable taking her to the men's dressing room, and so asked the child to stay outside. Well, you can see it creates an opportunity. So for those reasons, we said, no, there is no position in a JCPenney store where you can have somebody who has a sex offense continue to serve the public. So that's an example. But let's say we hadn't done the background check. We were prepared to hire this man, and we would have hired this man if we hadn't known that. But and let's say that he had gone to work for JCPenney and he had harmed a child or anyone else for that matter. Well, then obviously the victim would be in a good position to sue this man, obviously, but this man wasn't a wealthy man. They could also have sued JCPenney. So you have to, when you're dealing with customer-facing people, make sure that they don't have something in their background that could put other people in jeopardy. Also, you want to make sure if that person has a medical license or a professional license or something along those lines that could create an expectation of a certain level of care, that they have those credentials. Okay, so in the application process, obviously the employer has to decide what does the candidate have to do to apply? Are we going to accept emailed applications? Are we going to accept face-to-face applications? Do they have to complete an application, or is the resume enough? Is it just enough to come in and express an interest? When and where these applications will be accepted? How long and will the applications be processed, and how long will they be retained on file with this organization? All of those are questions that should be answered probably by the HR department to make sure. Let's say you have a policy that says applications will remain on file for 90 days. Well, you probably ought to have some purge process. Maybe at the end of every month you go back over the last 4 months and clear out all the applications that are over that period of time. And so you don't inadvertently keep applications in your credenza for 6 months or 9 months or whatever if your policy is 90 days. So you'll want to make sure that whatever policy you establish, you consistently follow that policy. And if you're not the one policing it, then you have to make sure whoever is responsible for that has that on their to-do list. Maybe it's a weekly task, maybe it's a monthly task, or maybe it's some kind of automatic procedure. Maybe you have all of the applications online and the computer itself deletes them every day as you get farther and farther from the 90-day point. Let's look at what the rules are about retention. Applications and related records have to be kept 1 year after a hiring decision is made. Records relating to who was hired have to be retained 1 year after they leave employment. So let's think this through for a second. We have 2 candidates for a particular position. Bob applies on January 1st, 2019. Sally applies on January 1st, 2019. The decision to hire Bob is made February 1st, 2019. Sally is not hired at that point. So all the records relating to Sally have to be retained through until February 1st of 2020. Because she wasn't hired, the date that the decision to hire Bob was made is what starts the 1 hour clock for Sally. But for Bob, because he was hired, his clock doesn't start on the hire date. His start is going to be turned on for retention when he leaves employment. So let's say Bob stays with the company for 20 years. So now he was hired February 1 of 2019. He leaves employment, we'll say March 1 of 2039. Well, that clock then is going to start on March 1, 2039, and so his records can be removed or deleted until March 1 of 2040. So those are some processes to keep in mind. These are general rules of thumb, but you'll also want to check the state rules with respect to this, and these dates obviously can change over time. Most businesses tend to keep these records electronically, and so it's not a huge issue retaining these records for a while. You want to be sure, though, that you are having a consistent application of these policies. You don't want to have one unit retain records forever and another unit retain records only for a little while. So you want to have an industry-wide, or not industry-wide, but an enterprise-wide policy in this area. Who is an applicant for this job? We talked about this previously. Who an internet applicant is can be a matter of some confusion, because I might post a job, say, with Monster or Indeed, and a person might express an interest to those services for that position. Does that make them an applicant for my job? Possibly, possibly not. A person might contact me for an entry-level position, but doesn't really specify which position they're interested in. Probably under those circumstances, they haven't really applied for a job. You know, it's better to assume someone is an applicant versus not an applicant, and always treating them obviously with courtesy and respect and with no discrimination, obviously. But if you ever get a charge of discrimination from an applicant who really wasn't considered for an employment, you may be able to argue that that person doesn't meet the legal definition of applicant, and therefore there was no need to give them any kind of special consideration in the application process. Let's consider pre-employment inquiries. And these are pre-employment inquiries by the employer towards the applicant. Obviously, an employer should not directly inquire about protected class characteristics. So, for example, I shouldn't ask, when did you graduate from college? Or that last name, what part of the world is that last name from? Things like that are not appropriate for the interview process. They create an opportunity for that candidate, if that candidate is not a successful candidate, to say that there was some level of discrimination there. So you're opening yourself up for that type of exposure. You don't want to ask dates of graduation. You don't want to ask memberships in clubs. You don't want to ask for workers' compensation histories. And again, this goes back to the idea of, you want to, for those categories of questions, you want to have a clear list of what you can and what you can't ask in those areas, so that everybody who is on board and knows this is okay, this is not okay. Now you might say to yourself, well, why would a line manager ever ask about workers' compensation claims? And most likely they won't, but sometimes a conversation goes crazy ways. And so, you know, the applicant is in the office being interviewed, and somebody walks into the office and said, oh, Larry's back from his workers' compensation accident, first day back or something. And so that leads to a conversation topic that hadn't been planned for. And so somehow or another, the interviewer says something like, oh, I don't know if you know anything about workers' compensation, but I had to learn about how all the system works. And you've basically then asked this candidate, well, yeah, I do know something about it because I filed a claim 6 months ago. Well, guess what? You can't ask those questions. So it's a good idea to let the interviewers know all the topics they have to avoid, and also to periodically remind them, because obviously the interviewer most likely spends just a small portion of his work day or his work month actually interviewing. Some entities like to have professional interviewers, people that really, really understand the ins and outs of that for the first round of interviews. And sometimes that can make sense, especially if it's a situation where you are interviewing lots of people for a relatively low-skilled job, such as salesperson, in a department store, something like that. But then for other positions, more senior positions, or positions that require more detailed skills or more specialized skills, that may not make sense. So it's a job of the HR to keep the people doing the interviews aware of what's appropriate to ask about, what's inappropriate to ask about, what's appropriate to consider when making the decision, and what's not appropriate to consider. These are examples of bad questions. I wouldn't say they're necessarily unlawful questions, but they create the opportunity for the candidate to misinterpret. Well, why do you care about that? I think I said in a previous lecture that, in my opinion, the most dangerous moment in the interview for the employer is that walk from the reception area back to wherever you're going to conduct the interview. If it's a very large facility, you might actually end up walking for several minutes. And it doesn't feel comfortable to ask about the resume at that point in time, so you kind of make small talk. That seems safe. But the small talk topics can lead into some dangerous areas pretty quickly. I'll give you an example. At JCPenney, we had a child care center on site. And we like to talk about it because it was actually a major draw for lots of employees and candidates. And so we had a lot of people that would tell us, I really wanted to come to work for you because you had this awesome daycare center right on site. And so as HR people were walking candidates around, they would usually say something like, oh yes, and over there is our daycare center. And so sometimes people would react kind of in a certain way and say, oh, really? And so the HR person might be tempted to say, yes, do you have any children at that age? Again, the HR person is just making conversation, trying to see if this is an important factor so that she can talk it up more and maybe give some more information. But in fact, this is getting information that is dangerous territory. So you have to think through those types of things. And of course, the temptation might be for the HR person to talk about the daycare center with female candidates or for candidates in their 20s and 30s, but not for the 50-year-old or 60-year-old candidate or for the male candidate. And so you can see that that isn't a good issue. So instead of asking, what is your date of birth? Asking, are you at least this particular age? 18 years old is usually the date in which any protections, the child labor law protections end. Are you a U.S. citizen? That's an unlawful question, except for very specified categories of positions that might involve governmental work or security clearance. Instead of after being hired, will you be able to document your eligibility for work in the United States? If you are an employer who doesn't want to sponsor somebody for a particular visa, it's appropriate to say, just so you'll know, we aren't, for this particular position, we aren't sponsoring these particular visas. You're not asking if this person were interested in those visas or needed those visas, you're just doing an FYI. That way, the candidate can opt out of pursuing this matter any further. That doesn't necessarily mean the candidate will do that, but at least opens up that possibility. This is a good list of questions to think about and giving you the alternatives of things that you might want to consider. Again, you want to be sure that when you ask a question, you're consistent. It's a good reason to have a list of set questions. For one thing, if you list them out in a well thought out way, you're not going to forget something that you need to ask, and you'll be systematic about it. And it also protects you if so you're not tempted to ask this question to this type of candidate and that question to another type of candidate. For example, you might not think that working late would be a problem for the male candidates, but you might start asking the female candidates, well, this job status requires late work. Are you going to be available for that? Well, that's a perfectly valid question, but it ought to be asked of everyone, not relevant to ask just of one group. It's not lawful for employers to ask compensation history for job applicants for disabilities. It's usually not a good idea to ask for compensation history of anyone. There's some developments in the law in the last year or so that make that more and more problematic. A better approach is to ask about what this applicant is looking for in terms of compensation. That's probably a smarter path, or to let the candidate know this is maybe the range, depending upon the experience the person brings, this would be the range that we would see this position being in, and therefore candidates who weren't satisfied with that range could opt out of further consideration. Okay, let's talk a little bit about the issue of medical inquiries. We'll talk about medical tests later on, so this is a little bit different than that. But employers shouldn't ask medical information of their applicants, whether they think the applicant is disabled or not. Um, uh, Even if they systematically ask everyone. So for example, they shouldn't ask about disabilities. They shouldn't ask about psychiatric issues or medical histories or workers' compensation issues being filed. None of that is appropriate for a question until an offer of employment is created. Now there's something in the law that we call a conditional offer of employment. We all know what an offer of employment is when the guy tells you or the woman tells you you got the job, or at least you're being offered the job. Maybe you'll accept it, maybe you won't, but you can accept it. A conditional offer of employment, you can probably figure out what that is, and that is when the potential employer says, we would like to offer you a job if you can do X or you can do Y. And oftentimes the if is going to be if you can pass a background check or if you can pass this particular test. Maybe it's a physical test to see if you are able to complete the tasks of the job or whatever. We'll talk more about that testing process later on. But medical inquiries are prohibited until you get to that conditional offer of employment. And the idea here is, at this point, when you're just interviewing, if you were to say, well, tell me about your workers' comp history or tell me about your medical history, then what might happen is that candidates who gave answers that the employer didn't like, their candidacy would not advance. But if you've offered a conditional offer of employment, then the employer's feet are to the fire. They say, we're going to hire you as long as this comes back okay. So if the employer decides to withdraw the conditional offer of employment and it's for an unlawful reason, that employee is in a very good position to say, wait a second, this is a violation of whatever the statute is, very likely the Americans with Disabilities Act. So it causes the employer to be careful about how they consider information they get through this process. An employer, of course, can ask the applicant if she can do the job or he can do the job and to demonstrate how the job can be done. Let me give you an example. Let's say that you're hiring a file clerk, and the file clerk, the filing cabinet that the file clerk would be working with has 4 drawers, and the top drawer is 5 feet tall. The candidate who comes in using a cane and seems to have some significant mobility problems. And so you're wondering, well, how can this candidate efficiently file these cards given these physical limitations that he or she happens to have? The way to approach that would be, and not just to single out the disabled person, but to say, well, how would you do this job? And so also appropriate to ask him or her to demonstrate how the job might be done. Now, of course, the candidate might say, well, I would need you to have a different filing system. I can't file up that high because of my physical limitation. I can file maybe up to 3 feet high. And so you would need to replace this 5 foot high filing cabinet perhaps with a wider 3 foot high filing cabinet, or maybe 2 filing cabinets. And I would be able to do it, and this is how I would do it. That would be an appropriate way. It's best to ask the same questions of everybody under those circumstances. If, though, you encounter a candidate who has an obvious disability, my suggestion would be for that first interview to treat that candidate as you would any other candidate. And then for that second interview, you have some time, because now you have time to prepare and draft the questions in a way that you know will be legally compliant. Because if you're doing it extemporaneously, you're surprised. You had no idea this person was going to come in a wheelchair or was going to come in with a significant visual impairment or whatever the issue is. And so you weren't able to anticipate exactly how to phrase the questions in a way that would be lawful. You stumble, you had the best of intentions, but you say it incorrectly. The candidate hears it and then files a charge against you. I mean, you're kind of sunk. But after the first interview, you know what you're getting into. You know that this person has this disability, so you can do the research, you can talk with the attorney, you can make sure that the way you phrase it is exactly right. You can write it up, and then when you ask it, you're going to be golden, and there's not going to be a problem with it. Plus, you'll have a record of exactly how you said it, because you'll be reading off of the sheet of paper. Okay, so let's talk about a situation of a conditional offer of employment. Following a conditional offer of employment, which again means the employer is saying, we will hire you if you pass this particular test. In this case, it's a medical test. So after the conditional offer of employment, the employer can make any medical inquiry or perform any type of medical test if all are subjected to the same inquiries and medical exams. So you can't say, well, gosh, you're in a wheelchair, so we're going to make you go to the doctor. But Bob, who's also getting a job, who is not in a wheelchair, doesn't have to submit to the test. And so you have to budget for things like this. And obviously, having lots of people submit to these medical exams is going to be an expense that you may not want to bear. It may not make sense from a business standpoint to do so. Just be aware that you can't, again, single out the one person. Let's talk a little bit about social media. This is a controversial area. There's a lot of change in the law in this area, especially on a state level. Several states have enacted statutes that have limited the ability of employers to check Facebook and Instagram and other social media websites. At this point, and I'm making this video in 2018, but at this point there have not been any statutes in Texas. So we don't have any limitations on how employers can use that data. There are lots of large employers especially, but certainly smaller employees as well, who do look at the social media, who will do their own inspection or who will require passwords from candidates who they are seriously considering and see what's out there about them. I have some slides here that might be of interest that show you kind of where employers go for information. Now, I would say, I'm not quite sure how they're using MySpace these days. That's kind of a little surprising. But LinkedIn, I don't think anyone would really say that's an appropriate place for an employer to look, because the whole purpose of LinkedIn is a professional networking site. And it's very, very common for employers to do this. This data, I think, is fairly dated. I would say in 2018, many more than 26% of employers are going to be looking for LinkedIn. One of the neat things about LinkedIn for employers is that, an employer gets a resume or an application from a candidate. That's really a private document. Nobody else other than the employer and the candidate really see that document. So if I'm the candidate and I've seen what the employer is looking for, I can tailor my credentials to meet those requirements. Guess what? I can exaggerate. And it's pretty hard for employers to substantiate resume fraud. And so I may well get hired even though I don't have the qualifications. But let's assume I have a LinkedIn account. Well, that means that the employer can go to my LinkedIn account and see what I say on that account. I mean, the employer is going to expect that there's going to be some subtle differences. After all, my LinkedIn account isn't designed to respond to this particular job. So certain facts might be highlighted a little bit differently. But you ought to be able to see the same dates of employment, the same employers, the same position. You ought to have a sense that this is the same person. If there are significant differences, then that would be a kind of a red herring that perhaps there's some resume fraud going on here. Now, you might say, well, gosh, a person could lie on their LinkedIn account just as easily as their resume. That's true, but people are less likely to lie on the LinkedIn because it is a public reference. Your friends, your colleagues, your acquaintances, your family are going to have access to your LinkedIn account, and usually people don't want to lie kind of that publicly. They could, certainly, but it seems to be a little bit less common. So LinkedIn can act a little bit as some kind of informal means of confirming the information on the resume. And that's a good thing for you as you're looking for places of employment to consider that whatever you have in your LinkedIn account should match pretty closely with what's going to be on your resume. And again, here are some things that the employers might be looking for as reasons not to hire future candidates. Okay, let's think about statements by employers. We talked before about how the recruitment process is really the exchange of information. The applicant is giving information to the employer is giving information to the applicant. We've been focusing on the information that the employer is getting from the applicant, but again, there's that flow back too, and that can sometimes be problematic. An employer might misrepresent aspects of the job, chances of advancement, hours worked, pay or benefit information, working conditions, those types of things. And so it's possible for an employer to misrepresent it. The applicant quits his current position or her current position and goes to work for the employer and then finds out that things aren't as they were represented, and therefore that candidate who's now an employee really is somewhat stuck there until he or she finds another place of employment. So let's consider how that situation might play out. An important word in this analysis is going to be fraud. What is fraud? It's a misrepresentation of a material fact with intent to deceive, or recklessness about its truth or falsity on which the applicant reasonably relies to his or her detriment. So what we need some kind of misstatement. It can be intentional or it could just be reckless, meaning that the person said it not really even bothering to confirm the facts. They didn't know it was wrong, but they acted as if they knew it was correct. So there has to be some misstatement, some fact, some lie, some characterization that isn't going to pan out. The second thing is it has to be a material fact. For example, if somebody said, let's say in the interview process, the applicant said, am I going to have a monitor of this size on my desk in my cubicle? And the interviewer says, yes, that's the size you'll have. Well, it ends up when the person starts work, the monitor is an inch smaller. Now, I can see how that's less than ideal, but unless the person has some kind of disability circumstance, that qualifies as a misrepresentation, but I wouldn't say it's a material misrepresentation. In this context, material means important, significant, the type of fact that could have caused the candidate to make a different choice. A significant pay difference, let's say the interviewer says, well, your pay rate will be $40,000 a year. The successful candidate shows up to work on the first day and is told, no, it's going to be $30,000 a year. I'd say that would be a misrepresentation of a material fact. Employers can be found guilty of fraud in recruitment if they allow an applicant to believe something about the job that they know is false. So let's say an applicant says during the interview, I'm sure that y'all will pay will provide dental benefits. The interviewer is thinking, we don't have a dental policy. But the interviewer doesn't say one way or the other, nor does he or she later on provide information to clarify that. And so the applicant starts work and then learns at that point, oh, no dental insurance. Well, that was a major issue because this particular candidate had some major dental work that he was or she was expecting that needed to be done. That could be a situation where the interviewer knows what the interviewee thinks is the case, isn't the case, and doesn't correct the information. That can be a situation of fraud. So here is the elements of a fraud claim. So this is the same definition that we have here, broken down into the various things that the successful plaintiff would have to prove. A false statement of material fact was made to another person. In this case, it's going to be the interviewer making a false statement to the interviewee. The party making the statement, in other words, the interviewer, knew that it was false at the time that it was made, or again, had reckless disregard for the truth. The party making the statement, the interviewer, intended the interviewee to rely upon it, to trust that information. Yeah, don't worry, we have great dental benefits here. The other person, the interviewee, was in fact induced to act based upon it. So the interviewee actually did take the job because he trusted the statements of the interviewer. And the other person was harmed. The interviewee was harmed. The interviewee needs to have dental work done. There's no dental insurance, so he has to pay for that out of pocket. So that would be an example of how the fraud case can be proven. Let's look at this statement. Despite the employment at will doctrine, let's pause here and do a little refresher on employment at will. Again, we mainly cover that in a different module, but let me do a refresher. Employment at will means that the employee can leave at any time with or without reason, with or without notice. And the employer can end the employment relationship at any time, with or without notice, with or without cause. The only exception being that the employer cannot end the employment relationship for an unlawful reason. Okay, so you might think, well, gosh, since an employer can end the relationship at any time, how about this scenario? Imagine that an employer says, yeah, we're offering you a job. You'll earn $50,000 a year. The employee accepts the job, quits his current position, comes to work at the new job, and works there for one day or 1 week or whatever, and then is fired. And he's not fired for any reason. The employer just says, we changed our mind. But I had a steady job. I was earning $45,000. I can't go back to my job, and now I'm on the streets. I can't even get unemployment because I wasn't employed here long enough. That's your problem. We never promised you that you would have a certain period of employment. You were employed at will. Very likely, the employer is not going to be found to have committed fraud unless he represented to the candidate a certain level of certainty about the stability of employment. So employment at will is going to remain the assumption of the relationship. So, despite the employment at will doctrine, a company representative who makes an intentional or negligent representation that encourages an applicant to take a job may be liable if to that applicant if harm to the applicant results. So, the employment at will doctrine doesn't remove all of the types of fraud claims that the person might make. I'll do a little reminder here. Sometimes people conflate or confuse employment at will with right to work. So let me just make a little bit of a clarification about this. Right to work has to do with union scenarios. If you don't have a union, there is no issue in an employment relationship about right to work. Right to work in the union context has to do with whether a particular employee has to join the union in order to maintain his or her employment. In the state of Texas, a person can't be forced to join the union or pay union dues to maintain his or her employment. That's what right to work means. It has nothing to do with employment at will. It has nothing to do with employment relationships that aren't in a union setting. Right to work is the rule in Texas, as is employment at will, but you do need to keep those two straight. Lots of folks get those two confused. Let's look at this scenario. This is a negligent misrepresentation scenario. So back here, we had the situation where the statement was made intentionally. The person knew that they were lying when they made the statement, the interviewer, but it also can happen negligently. The person hasn't actually committed fraud in this scenario, but they've just said something that was untrue, and they thought it was true at the time, but they should have been more careful. Basically, that's the situation. So it's not fraud, but it still can create, obviously, problems for the applicant. So let's consider a fact scenario here. So Bob's hired to work for Eager Beaver under the employment condition that for the first 3 months, he will not be eligible for any types of incentives or commissions or whatever. Based upon Bob's performance during that 3 months, the company will classify him after that as a permanent employee, if, of course, he's successful, and raise his salary by 10%, and then he'll start getting some commissions. However, even after Bob performs above the standard during the first 5 months, I guess I should say, of his employment, the company refrains from acting accordingly to avoid certain costs. So they don't make the transition at the 3-month point. They haven't even made it to the 5-month point. Thus, Bob can avail a cause of action for intentional or negligent misrepresentation. He was told his status would change at the 3-month point. It wasn't changed, even though he was satisfied whatever that standard was. And so he could establish a claim at that point of time because he was told one thing in the application process and a different thing happened once his employment began. So we've gone through lots of different recruitment topics. We've talked about discrimination. We've talked about how to recruit, the different methods. We talked very briefly about the visa issue. We talked about how applications should be handled, what types of questions can be asked during the pre-employment process. We talked about the increasing use of social media by interviewers to see kind of more information about the candidate. We've talked about what statements an employer can make that can cause there to be exposure for that particular employer. Now let's talk about statements by employees. Obviously, employees need to be careful about what they say. That's pretty obvious. You make a statement, a false statement, for example, about your credentials. You are very likely, if the employer discovers it, your candidacy isn't going to go forward, even if you are a good candidate. Imagine for a second that you have very good skills, but you say something during the interview that the other side knows isn't true. For example, you might say, oh yes, Sally Green was my supervisor over at this particular time. Well, the interviewer happens to know Sally Green, and the interviewer had already talked to Sally Green. Sally Green says, yeah, I remember the guy, but he never worked for me. I can't speak to his particular skills. Well, at that point, probably the interviewer has zoned out and is not really going to consider this candidate any further because he's figured out this candidate has exaggerated or misstated a fact. And in most cases, when an employer knows or an interviewer finds that out, the candidacy isn't going to go any farther, even if on paper this person was really, really good. Employers who discover falsehoods or omissions absolutely have the right to fire. So even if the candidate's doing great at the job, let's say the person misrepresents something during the application process, is hired, and is maybe doing a great job, but it comes to light at some point during the employment that he misrepresented his credentials. Most employers in those situations will fire even the strong performer, and the courts have said, yeah, that's fine. Another thing that sometimes comes up, and this is actually a fairly common scenario. Let's imagine that Bob misrepresents something on his application. He's hired, and he goes to work and he's doing great for some period of time, but years pass, and now he has been terminated, and now he's filing a lawsuit against his employer. Well, through the discovery process, through that process where the lawsuit is filed and the sides exchange information, it's very likely that the employer's attorneys will ask lots of probing questions about everything about Bob, including Bob's work experience before his employment began. And so let's say it comes to light during that process that Bob misrepresented his credentials because, Bob is required maybe to produce his transcripts from his college, or maybe depositions are ordered of his former employer, and it comes to light that, well, no, Bob really didn't do these job functions in his previous place of employment. So what happens in that situation? Well, this is called after acquired evidence. Obviously, the evidence has been acquired by the employer long after it's relevant to Bob's employment. Bob doesn't even work there anymore. But of course, the employer is going to say, wait a second, if Bob had been honest with us, we never would have maybe hired him in the first place if he had told us the truth on his resume. Or if we had found out that Bob had lied to us, we definitely would have hired him. So either way, we wouldn't have hired him, and therefore Bob wouldn't have ever been fired by our company. So it's really Bob's fault that we're in this mess to begin with, and we shouldn't, even if Bob can somehow or another prove that he was a victim of some type of discrimination, Bob shouldn't have to prevail because he only got to this predicament because of his misrepresentations. That theory that employers advance has actually not been complete. It's kind of partially successful. Let me explain to you how it plays out. The U.S. Supreme Court has a decision in this area. You're not responsible for knowing the decision, but you're responsible for knowing kind of how it works. And that is, the court will say, well, we're not going to go back in time and say, well, Bob lied on his resume. If the employer had known about the lie, never would have hired Bob, so therefore Bob can't win any type of lawsuit against the employer. That's not the rule. What the rule is, though, is that whenever the employer finds out about the lie, if the employer can persuade the jury that the employer would have terminated as soon as it found out, then Bob is not going to be eligible for any damages after that time. And it may be that the only reason the employer found out about this information is because of the lawsuit, but it doesn't really matter why. Whatever that date is, then there's not going to be any more back pay or front pay from that point on, if in fact Bob persuades the jury that Bob was, discharged because of his gender or race or whatever the thing is. So it cuts off future damages from that date going forward. So at this point, we've gone through all of the recruitment topics. In our next lecture, we'll talk about testing, and this is the pre-employment testing. This is that after that conditional offer of employment in many cases, although not always. Some types of testing can happen without that conditional offer of employment. So I thank you for your attention. As always, if you have questions about the subjects that we're covering here, please don't hesitate to send me an email or to stop by my office hours so we can talk about it in more details. Again, I thank you for your attention. I hope you have a great day. Take care.